Hey guys, I'm a criminal defense lawyer with KPA Lawyers in Ontario. Today I'm going to talk to you about what you need to know about being a surety. If you're watching this video because you're thinking about being someone's surety, you should know that you're entitled to get independent legal advice about the risks and responsibilities a surety may have. You can call me to get specific legal advice about your situation. In this video, I'm going to cover what a surety does and some common questions about being a surety. So first of all, what is a surety? A surety is someone who agrees to supervise a person who has been charged with a crime while that person is out on bail. We often call it being a jailer in the community. A person who is on bail will have a list of conditions that they have to follow, and it's the surety's job to make sure that all those conditions are met. For example, a person on bail might have a curfew. It'll be the surety's job to make sure that curfew is not broken. The surety can decide how they plan to do that, maybe by physically checking on the accused or calling a landline and speaking with them. But it's the surety's job to make sure that curfew isn't broken. Along with making sure all conditions are followed, it's a surety's responsibility to make sure the accused attends all required court dates. That means that the surety has to keep up to date with the accused court case so that they know exactly when the accused needs to attend court. Now that we've gone over what a surety is, let's address some common questions people have about being a surety. Will I have to pay any money? Bail in Ontario is not like bail in the US or on TV. As a surety, you usually don't have to pay any money upfront to bail someone out of jail. A surety has to make a financial play. That means you promise you'll pay a certain amount of money if the accused breaks any of their conditions and the Crown asks the court for the money. There will be a hearing and a judge may order you to pay all, part, or none of the money. To be approved as a surety, you'll have to show the court that you have enough assets to cover the amount of bail. This can be real estate, savings accounts, investments, or other assets like your vehicle. There are some circumstances where a cash deposit is part of the bail. For example, a deposit may be required if the accused lives far away from the court where the charges are. The deposit will be returned once the case is over if the bail conditions have been met. Be aware that the deposit will be returned to the accused directly and not to the surety. Can I be a surety if I have a criminal record? There is no rule that a surety must not have a criminal record. It's up to a judge or a justice of the peace to decide if a surety is suitable. They will look at the surety's finances, personal character, background, and relationship to the accused. It is possible to be approved as a surety even if you have a criminal record, especially if the record is dated and you can explain to the court what you learned from that experience. It is usually preferable for a surety not to have a criminal record, but it's not always necessary. How long will I have to be a surety? A surety's responsibilities last until the case is completely over. In some cases, this can last a very long time, especially if there's going to be a trial or a preliminary hearing. There are 3 ways to stop being a surety if you don't want to be a surety anymore. 1, you can bring the accused to court personally and ask to be removed as a surety. 2, you can go to court on your own and ask to be removed. If you do this, a warrant will be issued for the accused. 3, you can make arrangements to have the accused and a new surety come to court and switch sureties. What do I do if the accused breaks a condition while I'm a surety? Your responsibilities as a surety are to call the police if you find out a condition is not being followed. It's important that a surety understand this and be willing to make that call, because this can have an effect on whether or not they have to pay the money they promised at the hearing. I hope that answers some of your questions about being a surety. Remember, this video is not intended as legal advice. If you need independent legal advice about being a surety, you should definitely call a criminal defense lawyer. Don't forget to like and subscribe to KPA Lawyers on YouTube and Facebook.